and thank you everyone for coming today. My name is Brenda Gunn. I'm a Métis woman from Winnipeg, Canada, and I'm excited to be the co-chair of the Rights of Indigenous Peoples Interest Group. And I'm really excited today to be here with my co-chair, Harry, and three wonderful panelists to talk about Indigenous peoples and international trade law. About, I don't know, it was in the summer or maybe even at last year's business meeting, the interest group started thinking about what are some of the key issues that are arising that we could start having conversations about. And so one of the topics we began to think about is Indigenous peoples and international trade law, and the way in which that topic is becoming increasingly important and relevant for Indigenous peoples, both as they actively engage in international trade, contribute to negotiations with nation states in their discussions for international trade, but also the way in which international trade can potentially negatively impact Indigenous people's rights. So we thought this would be an area of interest to our interest group, but also more broadly. So I'm excited that we were able to pull this panel together despite the difficult and challenging times. But of course, there's also the benefit because we're all now used to gathering online and being virtual, and it allowed us to come together perhaps at a time that we might not otherwise have been. So I just want to, before I turn it over to Harry, I want to acknowledge that I am currently sitting in my home office, which is in Winnipeg, Canada, which is on Treaty 1 territory, the homeland of the Métis people, my homeland, and also the Dakota peoples and other shared territories. Now I recognize we're all sitting in various places, and so I'm going to welcome you all, if you want to use the Q&A function, to share where you're sitting and recognize the territory of the Indigenous peoples for whom land you are currently sitting on. So I invite you to do that, and we'll just all enjoy seeing where everyone is at. But with that, I'm going to turn it over to my co-chair, Harry, to introduce himself and our panelists for the day.
Thanks, Brenda, and thanks everyone. I'd like to echo Brenda's thoughts, and thanks to everyone who are attending today. I'm in Sydney, Australia, so I'd like to pay my respect to the Gadigal people of the Eora Nation, whose traditional land I'm on today in Sydney. I'm a non-Indigenous person from Australia, and I'm really pleased to be part of the American Society of International Law. Wes was saying, 40% are non-American, and I'm one of those 40%. So I think it's great to have such a wide collection of scholars from all over the world who are interested in society and interested today in a discussion on Indigenous peoples and international trade law. We've got three great speakers today. We've got Risa Schwartz, James Hopkins, and Sergio Poig. And I'm going to introduce them individually just before they talk. So that's the order that we're going to start with. So first with Risa. So I'll just read Risa's bio out first, and I'll also send you a link on the chat function to Risa's page as well. So Risa is a sole practitioner focusing on international law and the intersections between trade and investment law, environmental law, and Indigenous rights. Risa formerly worked as a senior research fellow with the Centre for International Governance Innovation's International Law Research Program. In that role, she researched law and policy that supported increasing Indigenous people's participation in international law and treaty making. She has also held positions as counsel for the Ministry of Aboriginal Affairs in Ontario and the Ministry of the Environment, and worked as a legal officer at the World Trade Organization in Geneva in Switzerland. She has an LLB from Osgood and an LLM from the LSE in London in international and environmental law, and is a member of the Law Society of Ontario and the Canadian Council of International Law. And we're really pleased to have Risa today because she has published 2 books in the last 2 years on Indigenous people's rights and international law, particularly around trade. And Sergio's got one of the books right there. So the 2 books are Braiding Legal Orders with McGill Queen's University Press and Indigenous Peoples and International Trade, Building Equitable and Inclusive International Trade and Investment Agreements from Cambridge. So if you enjoy the talk, I think everyone here has, Brenda, Risa, James and Sergio have all got chapters in the book. So if you'd like what you hear today, make sure you get a copy. Thank you, Risa.
Okay, great. Well, thank you very much, Brenda and Harry, for inviting me and the other panelists. Very excited to talk to everyone today about Indigenous peoples and international trade and investment and some of the new areas that have being explored I think in the past couple of years, definitely last 5 years, this area is really growing. So I'm going to give a quick overview, sort of like a case studies of 3 separate countries and what's happening in this area. So first, just to give an overview of what's been happening in international trade, the preferences for Indigenous peoples in free trade agreements have proliferated and evolved. They've moved from exceptions and carve-outs, and examples of those are found in government procurement at the WTO, and in investment and services provisions. But there's been a shift towards recognition of Indigenous rights, and that's sort of the focus of today. The most recent area, and thanks for sharing the slides, most recent area is Article 32.5 of the new NAFTA. I'm going to call it the new NAFTA because in each country it has a different name. I've put a few down, but none of them are as catchy as NAFTA. And this agreement, which has come into effect as of July 1st, has a new article which protects Indigenous rights. And I'll talk about that a bit more as we go on. What are the influences and why has there been a more, I would say, this evolution that's been happening over the past 5 years, even though there's been a lot of advocacy probably for the last 20 years. I think some of the influences, especially in Canada, are the Truth and Reconciliation Commissioner's calls for action, which happened in 2015. The UN Declaration on the Rights of Indigenous Peoples, which certainly came into effect many years ago, but Canada, New Zealand, Australia, and the United States only endorsed it in, I believe it was 2010, but Canada endorsed it yet again in 2016, which has changed a lot of policy here. And also New Zealand and the work that's been done there with bilateral agreements and the Treaty of Waitangi exception, which I also will discuss in greater detail. So on my next slide, I discuss some of the evolution of Indigenous related provisions in trade agreements. And I think a big shift happened with the new NAFTA starting in August 2017. And this is when Canada mentioned that it had negotiating priorities for the new NAFTA. And one of these included a trade and Indigenous peoples chapter. And I think that took Canada's trading partners by surprise. There was a lot of interest and a lot of articles actually in the press in Canada. What was going to be in a trade Indigenous peoples chapter? It was going to collect all the preferences and also have all the carve-outs that were in other trade agreements. But it would also have established a committee with the participation of Indigenous peoples to determine how to better implement these preferences, as well as discuss internation trade. Unfortunately, we didn't see when NAFTA came in, the new NAFTA came into effect, a trade and Indigenous peoples chapter, but what we saw was mainstreaming of some of these provisions throughout the NAFTA. So the traditional preferences and carve-outs for procurement, state-owned enterprises, services and investment remained, but there were some new rules, a rules of origin provision for Indigenous handicraft goods, and a new dispute settlement tool to protect Indigenous rights. And on the next slide, I've just put the Article 32.5 so everyone can see what this new Indigenous peoples' rights provision says. And if you're familiar with the Treaty of Waitangi, you'll see that there are a Treaty of Waitangi exception that's in the New Zealand trade agreements. You'll see that there is some overlap with the language, but it's actually a broader exception. The Treaty of Waitangi exception relates more to carve-outs. It doesn't specifically mention rights. And here we're talking about the agreement doesn't preclude a party from adopting or maintaining a measure that it deems necessary to fulfill its legal obligations to Indigenous peoples. So quite a strong statement. Canada put a footnote into the new NAFTA, mentioning its constitutional requirement, Section 35, which recognizes the rights of Aboriginal peoples in Canada. And this provision, as I mentioned, came into effect last July. So on the next slide, I'm going to just discuss a bit about New Zealand, because New Zealand, I think, is really leading the way. They were the first to have an exception to protect Indigenous people's rights, the Maori, in trade agreements. And this started in 2001, so 20 years ago, in the New Zealand-Singapore Free Trade Agreement. And it continued, and New Zealand was able to maintain this exception in the Comprehensive and Progressive Trans-Pacific Partnership. And why that's important is this is the first time that this exception was applied then to investment as well as to trade. I think what's interesting about the Treaty of Waitangi exception is that it hasn't been used. So there hasn't been a trade dispute that have implicated Indigenous rights. But I think now that it is in the CPTPP and also relates to investment agreement, the investment chapter of the CPTPP, there's a better chance that it could be used. Only time will tell. New Zealand also negotiated the first Indigenous Peoples Cooperation chapter in a trade agreement with Taiwan. So they're leading in many ways. And currently, New Zealand is engaging on the development of a new protocol, which would contain procedures and practice for partnering with Maori if there is a trade dispute or an investment dispute that implicates the Treaty of Waitangi exception. And I think that's important. So why are exception clauses important? The Waitangi Tribunal looked at the exception clause in the trade agreements, and it was a tribunal decision that was looking at whether the clause as written would be protective in the CPTPP, because now investment was going to be included. And the conclusion was that these clauses offer a reasonable degree of protection to Maori interests. These types of clauses allow, and for NAFTA, they will allow the NAFTA members to take actions to protect Indigenous rights and build a solid defense if a dispute is launched that implicates Indigenous rights. And I think where, again, within the new NAFTA, if there is an investment dispute, and here the investment dispute would most likely be between the US and Mexico, because Canada and the US are phasing out ISDS in the new NAFTA. But if there's an investment dispute, I think it will be very useful if there is an investor who has, and I give an example actually, that just happened recently. A couple of days ago, President Biden canceled development in the Arctic. And one of the reasons that was important is that it protects the porcupine caribou herd. And this was a measure that has been pushed very strongly by Indigenous peoples, First Nations of the Arctic, who want to protect that traditional area, frankly, because it has the largest caribou population in the Arctic and is relied upon for food and ceremonial purposes. There is a chance that this executive order that cancels future development might impact investment. So Article 32.5 potentially could be important for something like that. I think that gives a good example of where you could use these exception clauses and why they are important. It does get a bit more complex with the new NAFTA because there are some questions as to whether Article 32.5 could be used as between a Canadian investor, let's say in the Arctic, or because of the phase out of this, the ISDS provisions. But I think it sort of makes this idea real, what types of investments could be implicated and where you could use Article 32.5 to defend a measure. All right, and in Canada, it's having these types of articles, and it's not just the new NAFTA where Canada is now trying to seek exception clauses, but in all its new negotiations. It's important because these types of provisions would protect land claim settlements that potentially led to cancellations of investments or decisions taken by Indigenous peoples through self-government agreements that also could potentially impact investment. Great. So I'm just going to conclude just to point out a few areas to watch in this area. One, as I discussed, the creation of protocols for article exception clauses. So how are Indigenous peoples themselves going to be involved in the defense of these types of disputes that implicate their rights? And luckily, New Zealand opened that door to the conversation. Hopefully, Canada will also sit down with Indigenous leaders and academics to start discussing what a protocol would look like and how there could be participation by Indigenous peoples directly in the defense. And there is a precedent in Canada to follow it, because if there's measures taken by a province that lead to a claim or led to a claim under NAFTA Chapter 11, which was the investment chapter of the old NAFTA, the province would work with the federal government to defend the claim. So certainly the Canadian federal government is used to working with other governments for defending ISDS complaints. And other areas to watch out for that are, there are new negotiations going on in the Pacific Alliance, where both Canada and New Zealand are negotiating with Pacific Alliance members and looking to include Indigenous rights provisions. There's been an inclusive trade action group established sort of pursuant to the CPTPP, where Canada, New Zealand, and Chile are members. They're also discussing Indigenous rights and developing an Indigenous trade arrangement, as well as implementation of the Canada-EU trade agreement, where there has been a proposal brought forward by Indigenous organization to allow for implementation and consideration of Indigenous rights by both Canada and EU members. And as well, Canada is also developing a new model for international investment, their FIPAs, and we may see a change and the inclusion of an article like 32.5 in Canada's model FIPA. Great, and that will conclude the presentation, but I hope there'll be some questions to discuss later. Thanks.
Thanks very much, Risa. I should have mentioned as well at the start, I mean, you were perfect on timing, but panelists will speak about 10 to 12 minutes. And please ask, so thank you, you're bang on 12 minutes. Panelists, we have 10 to 12 minutes. Please, if you have any questions, you can raise questions in the Q&A chat box throughout the presentation, and we'll answer them at the end. The way it's going to run, is 10 to 12 minutes of each panelist, and then 2 to 3 minutes at the end, just for each of them to sort of respond to what they've heard or give a final concluding point. And then please ask questions as you go, and we'll come to them in order after the panel. But thank you, Risa. Our next speaker is Professor James Hopkins. James is an Algonquin Métis from Quebec. He's a former law clerk to the Ontario Superior Court of Justice and is a member of the Ontario Bar. Prior to joining the College of Law at the University of Arizona, he was an assistant professor with the Faculty of Law at the University of Alberta. He's a graduate of Harvard Law School's Joint Masters of Laws and International Tax program. Professor Hopkins' area of interest is the intersection between trade, tax, and Aboriginal law. So we're very excited to hear him talk today. Thanks, James.
Thank you. And hopefully everyone can hear me all right. And I'm speaking to you from the traditional territory of both the Pasquayaki tribe and the Tohono O'odham Nation here in the Tucson Valley. And so what I'd like to talk about in the time that I have is a couple of general points and then a very specific point that speaks to the practice of Indigenous law. And in terms of general points, it's hard to capture the significance of the new NAFTA. You have to appreciate back in 1996, when I was in law school at the University of Toronto, these conversations with, for example, First Nations leaders were typically couched on the idea that trade was something that was a pre-existing bundle of sovereignty, and it really found itself under the guise of self-determination. And as some of you might remember back in the 90s, self-determination was really a hot button issue. So this is before the UN Declaration on the Rights of Indigenous Peoples is passed. And so there's a number of cases that go towards this idea. In Canada, there's a case that I had the pleasure of being involved with in terms of the quote unquote the offenders, which is the Crown v. Frank, which is a Canada Wheat Board decision, where a member of a First Nations in Alberta attempts to willfully drive across the border to sell wheat and grain, to his sister community in the United States. But that case is quickly kind of passed over, and the parties negotiate kind of out of court, essentially. So it doesn't become the sort of seminal test case, but it echoes that there's something there. And so there's these other discussions that come up. Under the Softwood Lumber Agreement, there's some work in petitioning the legality of the calculation of stumpage fees and whether or not it constitutes an unfair subsidy, given that it's on Aboriginal titled land, et cetera. But all of these are relevant, I think. And of course, it goes without saying that the NAFTA had enormous consequences, a sea change of consequences, I think, in Mexico, both in the lead up to it and after. And much of my work, in fact, all of my work really has been focused on that. With the Rio Yaqui Pueblos in Sonora, Mexico, which is a major trade hub for agricultural goods or products into the United States. And I've spent about 8 years working there. And I've had a broad exposure. I've had to deal with, for example, the post-NAFTA ejido reforms, where some of my clients have quote unquote been ejected off their land by newly arrived and newly anointed ejido owners who want to kick my Indigenous clients off their land, and they have court orders allowing them to do that with the privatization reforms to the ejido system. So I've seen the unfairness to global trade as well. But so from this kind of distance of observation, I want to come back to the idea that this is I think a sea change. And I think when I reflect on Risa's presentation and the reference to carve-outs, there's enormous opportunity and really some flexibility to negotiate if you're an Indigenous group that has the support of your nation state's government. So that's one thing I would just want to emphasize, is that it is the beginning, but there's lots of opportunities in the new NAFTA. The one that I'm particularly interested in is it's in regard to broadcasting. And my colleague Sergio has been very helpful to me in my research on this in terms of the role of Indigenous broadcasting in Mexico. And so I've begun doing extensive research on Indigenous broadcasting and its role both in Mexico and Canada. And it's interesting because then you realize with broadcasting, anytime there's a lot of heavy federal regulation, there's usually a lot of money involved. And so sure enough, you quickly realize that broadcasting in all new NAFTA member states, Mexico, Canada, and the United States, have strong federal oversight over broadcasting jurisdiction. And there's really good arguments to be made about an Indigenous right to broadcasting. And in that general sense, interestingly enough, the new NAFTA actually goes to some degree, I think, in advancing that idea further. So again, my final sort of general point is please read the new agreement and Reese's slides. So the details are really, really important. More into specifics in the final part of my discussion. So I'm very close to the border with Mexico, and I work with a number of border First Nations and Indigenous peoples. It just breaks my heart to walk through Nogales, Sonora, and see Indigenous peoples in this past administration with the Trump administration sleeping on the sidewalks or right by the sewer drainage spouts at the border, like literally at the border. It's hard to describe, unless you've seen it, the hardships that Indigenous communities can experience south of the border. And that's not to take away from any of the harsh experiences or injustices experienced by Indigenous peoples generally or more specifically. But it's ironic because trade has such an important role in shaping some of those power dynamics. And I think we're at a crossroads where the new NAFTA speaks to an opportunity. And what I would really, really like to see, and its timing is everything with the COVID pandemic, it's hard to muster attention to this, but it would be wonderful if all three governments really got behind the commitments that they made, because I don't think they all are aware of the commitments that they've made under the new NAFTA to Indigenous peoples. And so that's really part of what my clinic is trying to do at the law school. It's a very small effort, but even just trying to explain the chain of transactions, both with the goods that move from Northern Sonora into Nogales, Arizona, the issue of dealing with brokers, the mechanics associated with that, and the rules and regulations, and then the economics. None of that information is readily available, I think, to the public. And so this is just one example of how I think there's a great opportunity, and my hope to come full circle is that we can start to begin a really serious dialogue about the kind of nuts and bolts of how international trade works. Because the groups that I work with, they know that there's great opportunity. They all understand that if you can move your goods, whether it's making furniture, as some of them do, or artisanal crafts, they know that if they can move their goods into the United States, they stand to make a sizable return. And that actually is the case. It's just they have no means to do it. So that's really my hope at the end, is that we can maybe use this as an ongoing discussion. My real hope is that somebody in the government will kind of take this as their charge and their responsibility. But because Indigenous groups won't be able to do it alone, you have to deal with government throughout the whole process. And I think on that note, I think I'll just conclude there. So I thank you for your time.
Thanks, James. I think it's a really interesting point, the one you bring up about the fact that perhaps some of the governments are not really clear about what they've necessarily agreed to or the commitments that they've made as part of the new NAFTA. And I'm sure we may have some questions about that towards the end of the discussion. So thank you again. I might move along, though, leave questions to the end. So I'll just move on to our third speaker now, Sergio. So Sergio Poig is a professor of international law at the University of Arizona as well, a colleague of James's. Sergio's previous academic track includes positions as a lecturer and teaching fellow at Stanford University and Duke University in the schools of law. He's an expert in international trade law, international investment law, free trade agreements, and international dispute settlement, with a particular focus on the NAFTA and hopefully the new NAFTA as well as the economic rights of Indigenous peoples. With 20 years of legal experience, Professor Poig regularly serves as an arbitrator and advises governments in the negotiation and implementation of international economic agreements. Before entering academia, Professor Poig practiced international law and arbitration in Washington, DC and Mexico City, where he's licensed to practice. He also worked as a legal counsel of the Secretariat of the International Centre for Settlement of Investment Disputes, that's ICSID, ICSID, the world's leading institution devoted to international investment dispute settlement, and as a diplomat at the World Bank assigned to the Latin American and International Affairs divisions of the legal department. So once again, we're very happy to have Sergio here, and thanks so much for your presentation.
First of all, I am too in Pasco Yaqui and Tohono O'odham land, and thank you very much for the invitation and for allowing me to share my views on this topic that I'm a newcomer compared to everybody who has so much experience. So thank you, Brenda. Thank you, Harry. Thank you, Reese, and thank you, James. And in many ways, my reflections right now are a consequence of many years of conversations with James and other really amazing people who teach at the University of Arizona, or has passed through, like Brenda or Risa as well. So thank you all who in a way are part of that. I want to just briefly talk about my view on this topic, which is reflected now on my upcoming book, At the Margins of Globalization. And I was hoping to have a little bit of not a copy, it's not yet, but at least a document to show you, more what it is at stake. But for some reason I was unable to get it. But what I want to get into is perhaps the content of the book that relates to the questions that Risa was raising, and James really continue with more that experience here at the border. And it is how international trade, investment, IP, and finance agreements tend to create opportunities for indigenous peoples, but also they do create affectations, right? They affect indigenous peoples. And in the book, what I'm trying to do is provide a theory of how the modern way in which we deal with globalization, with trade agreements, with financing that, or the financing of international, or financing that is so dependent on international banking institutions, including the World Bank and the International Financial Corporation, and intellectual property agreements, in general affect the life of indigenous peoples. And overall, I think what I come to the conclusion in the book, and I'm gonna try to get you there, is that international economic law, which is basically what I do, has missed an opportunity for many years to really learn from indigenous peoples, and with that has at the same time marginalized many groups from the opportunities that globalization may provide. So I'm going to share my screen and just briefly guide you to some aspects of the book. And to start with, the book tries to basically create an easy framework to understand how, as I was saying, this globalization or economic globalization, and by that I refer to 4 types of agreements, right? Trade agreements that often contain investment provisions and IP provisions, international investment agreements that they're mostly bilateral investment treaties, or sometimes, as I mentioned, included in international trade agreements, intellectual property agreements, including the World Trade Organization TRIPS, and other similar trade agreements that contain intellectual property agreements, and financial agreements signed by countries within the framework of the World Bank, tend to affect or create or exacerbate the indigenous people's rights and policies. So I go into the depth of what I call the cycle of the susceptibility and exclusion, and this is a little bit of a synthesis of that cycle, where I explain that these treaties can have both direct or indirect effects on the political and economic domains of indigenous peoples, right? And in the first quadrant up in the left, right, it's what I call illegitimacy or lack of legitimacy, which is basically until very recently, most international trade deals were not affected by the views of international, by indigenous peoples, right? In other words, they were negotiated by large economic interests, multinational corporations, but they were excluded from the views and interests and, perspectives and, vital interest of indigenous people. So then this input legitimacy that's lacking tends to generate an economic effect, right? Basically, states, there's a tendency that because they are not included in these discussions, the way in which they are going to protect their interests is in imperfect ways, if they are at all, right? So the economic effect of that lack of input legitimacy tends to be discrimination. Discrimination in the way that they are treated, the discrimination in the way that they are unable to access the markets, and not just because there's a formal element to that, but because like the inequalities and the structural inequalities that affect the way that international trade happens are not compensated in meaningful ways. Politically also, the effects can be indirect, right? And then there can be what Schaefer and others mentioned, re-regulation. And in this re-regulation, of this idea that now regulating to participate in global markets tend to exclude as well the views of indigenous peoples. So these treaties can often demand new types of regulations that make more helpful for different participants in the economic space to succeed, right, in the advantages that they provide. But in this re-regulatory process, right, it's difficult for many tribes, especially in the global south, to defend their interests, right? So they can, the cycle that starts with this lack of input legitimacy and continues with this exacerbation of discrimination that is already existing, continues by this process of re-regulation that tends to exclude the views of indigenous peoples. And that cements what we already, the very existing inequalities. Now, this is a very, very formal way of thinking of the susceptibility of indigenous peoples. That doesn't mean that that's always the case. And I think there is a lot of improvement in the way of thinking about trade agreements and how to move away from this susceptibility. And that's what I try to do in the book. And that's what Risa actually also did a little bit right now, taking us to briefly how those provisions have evolved. And let me just take you quickly to the second part of the book, where I basically explain some of these aspects in more detail, right? So what are the provisions now included in most of these treaties that aim at addressing the consequences of these treaties, right? So basically, they can also be understood as provisions that protect some interest of indigenous peoples, right? So in intellectual property, many of these provisions is in international trade, investment, and intellectual property agreements, obviously, tend to protect cultural property and heritage and collective ownership. Although they can, of course, they can protect other interests as well, but those are the main ones that you found. In the legal form of these protections, it's positive legal obligations as opposed to only exceptions, as I will explain in a second, and Risa mentioned. And the demand to enforce specific protections within domestic proceedings, right? And here you can think of ways in which some treaties demand the sharing of benefits that come from the use of intellectual property of indigenous peoples, or the demand to disclose requirements and disclose the use of indigenous knowledge when something when an intellectual protection by intellectual property is being given by a state. When it comes to financial agreements, and here I think of the financing by the World Bank or the International Financial Corporations, or even other agencies in the similar domain, right? Like the Exim Export Bank, Exim Bank, and what have you, right? Here, I don't refer to private lending, as this is mostly public lending. And these provisions tend to protect self-determination and self-governance by indigenous people, by including in safeguards and operational policies, different requirements before the financial can take place, like impact assessments, free, prior, and informed consultations, and other type of mechanisms to ensure that indigenous peoples actually participate in the process as well. And oddly enough, trade and investment agreements tend to be a little bit more underdeveloped when it comes to these questions, right? I mean, that was one of the nice or unfortunate surprises, that there is actually more discussion on indigenous rights, and maybe because the origin of some of these issues on intellectual property and financial agreements than in trade and investment, right? In trade is mostly tend to protect social, cultural, and religious practices and economic preferences. And as Risa was saying, through exceptions and reservations or carve-outs that allow for preferential treatment or protection for economic development and lands as well. And that's and it's very similar to investment agreements, where sometimes, you know, perhaps the first one was the old NAFTA that created some protections, and then after that, some other agreements have replicated these protections that address land and natural resources and economic preferences through the mechanism of reservations. So in a way, things have happened, right? Not perhaps at the same pace, at that pace that we wish, but and of course, this is not there's states that have done an amazing work on this, especially New Zealand and increasingly Canada and other nations, but there's room for improvement. And then the last question is, well, how this is affecting the protection of indigenous rights and the protection of an economic law in general. And here, you know, this is the issue that I was mentioning, that, you know, the proof actually came with this title and this mistake. But basically, I try to go into two aspects in which the practice or in the engagement with indigenous rights in international trade and business law is affecting both, right? The way that we think in international trade, and also the protections for indigenous peoples. So there's two ways of thinking about that, right? The normative and jurisprudential impacts and the transformative impacts, right? On the normative impacts, what I suggest in the book is that indigenous rights are being enhanced by these protections, right? By these protections that actually exist in other documents, in other instruments of law, but also they are being created new swords, right, to open economic opportunities. And this is what indigenous advocates can focus in this in looking forward. And James make a very good point. I think there is an opportunity with the Biden administration, and actually a very interesting Mexican and Canadian approach to the issues, right? I think Mexico now is undergoing to a massive transformation of its constitution to recognize more protections and more rights for indigenous peoples. And I think this could be a nice timing to also address ways in which future trade agreements could actually create more opportunities or more swords for indigenous rights. And I think in the other side of the equation, right, the transformative impacts and the way that we think about international trade agreements, I think what the engagement is creating new standards and new metrics to measure the success of international economic agreements, right? How to think of them in more more collective ways, how to move away from that individualistic constraint metrics that sometimes we have to measure in very crude ways the effect of trade agreements. The practice of international economic lawmaking is also changing, and I think here, the diplomacy that tribes are engaging with governments and through their governments with other governments, it's really interesting, and I think that's something that it is also remarkable. And especially in areas such as traditional knowledge and the development of safeguards within the bank and others. The World Bank and other institutions, this is one remarkable development. And I think the future of trade agreements can see in social and developmental policy as a way forward, right? What do I mean with that? So basically, I think in the future, states with some leverage, like the US, Canada, and others, can actually condition economic benefits that can be granted through through trade agreements to the satisfaction of policies that protect and enhance and improve the life of indigenous peoples. And here there is like a really interesting, precedent now with the issue of labor rights in Mexico and the new NAFTA. But I think that could be also applied, or the same logic could be applied in the future to enhance indigenous peoples. So on that note, I think I would like to hear your questions and engage with Risa and Brenda and James and Harry on this topic. Thank you very much. Thank you very much for your time, and I look forward to hearing from you.
Thanks very much, Sergio. That's a really engaging and insightful presentation, and look forward to reading your book when it is out. I see it's out in April, so not long now.
Yeah, indeed.
We have a couple of minutes now. I thought maybe if James and Risa would like to respond to Sergio, or to respond to each other, or just provide any final thoughts, I guess, before we open up our questions. I know we have one Q&A question that's been posted already, but there may be more that come through. But I thought maybe Risa, if you'd like to go first and just have some something to sum up, and then James.
Great, thank you so much, Harry. I thought I would comment on a point that both James and Sergio talked about, more the practical implementation. How do we make these new provisions and opportunities real for Indigenous peoples across North America using the new NAFTA? I think I'll focus on the rules of origin provision for Indigenous handicraft goods. Although I don't expect it to be a major benefit for Indigenous peoples in Canada or the United States, it certainly could be a game changer for Mexico, where textiles is a very important industry for Indigenous peoples, especially if anyone's ever visited Oaxaca and the areas around there, you'll know the importance of Indigenous textiles. And I think the market for that could be huge. So this rules of origin provision also is not an exception. It's a rule that would allow for a preference for Indigenous, basically to move across the borders with no duties. And there are very high duties on textiles. So this is very important. But that needs to be implemented. So Canada has, done the work in its law to implement, but there needs to be a process decided upon by all three countries to allow these goods to start moving. So that's a good area to put pressure on by governments to get them starting working on that and implementing it. And why I think it's important is it sort of allows a new way forward for Indigenous goods. So here we're talking about a traditional good, textiles and other handicraft items that can be seen as textiles, but why not other things? Why not all goods made by Indigenous peoples, whether or not they are traditional? Why shouldn't they? This is what we're talking about when we're talking about international trade, allowing the goods to move across Turtle Island the way that they used to, allowing Indigenous peoples to reinvigorate their trade routes. And I think the rules of origin provision might be a good way to start that conversation. Thanks.
Thanks, Risa. James?
Yeah, just briefly, I wanted to mention that it was comforting in Sergio's chart to see reference to self-determination, and it just reaffirms some of the early tensions in this discussion going back 15 years, that the idea is that Indigenous peoples just want to move goods across the border carte blanche without any oversight, etc. That there's something kind of unfair about it, and that's not what this discussion is about at all. And I think more and more people are becoming more informed about it. And in the case of textiles, just as an example, with my clinic, there's a Yaqui woman that we've been assisting, and she makes the most beautiful floral Yaqui shirts. These are for women specifically, and they're given as gifts during certain times of people's lives. And they're hand stitched with really detailed floral arrangements, hummingbirds, and other reflections of cultural icons. And she makes them by hand. It takes her about 90 days, roughly 3 months, to make one shirt.
Wow.
She's never had dental care or access to a doctor for the most of her life, and she has one eye. And she does this by hand, and she sells the shirts for about $20 US along the roadside, which is the NAFTA highway. This is the Highway 15 that links the west side of Mexico with the United States. And actually, more or less, that's actually a fairly good price. We did a little bit of market research for what goods are selling in that area. But if we were able to somehow move this product, as billions of dollars of goods go north for about 6 to 7 hours and reach the United States, if we could sell that shirt in Phoenix, we could sell it for $120 easily. And she supports a very large family, and access to running water is limited, etc. So these are transactions in trade that have enormous consequence to better someone's life. I mean, at the end of the day, when you go through all the fine details, you just look at the amount of hard work that she's put into it, and that's really what I hope we could see out of this new NAFTA, is just getting the resources in government together to say, look, give these people a fair access, as we define it, to the US market, like all of the other big corporations do, so that she can actually get some kind of positive return on her work. So, I'm an optimist, but I think we're heading in the right direction, definitely.
Yeah, I was just going to add. I think this is a very good example, the textile, and I think the question is how to replicate them and you know find areas where those that you can get the most for the provisions, right? The biggest buck for your money, right? The low hanging fruit, and then build from that. And I think textile is one, and but there's other ways in which we can think of other areas where there is a large number of the workers and I mean in this case and Mexico and NAFTA are indigenous peoples, right? So I think sectors that can actually the agricultural sector of specific agricultural products. But now, I mean, but it's also tricky, right? Because there's when these type of concessions are created, if there's not a good organization and community that can actually take advantage, there create opportunity for capture, right? I mean, like you were talking about that woman in Nogales, right, or not far away, and then you can actually see how someone with a very entrepreneurial mind will go and buy them, and this money don't distribute in the way that you and I would like to see that distribution. So that also requires a lot more involvement by governments, and I think right now, especially in this context, in the context of the NAFTA, you have good governments, and especially with good leadership in the indigenous movement in Mexico, more of this could be done. But then I do think that's I think part of the problematic aspect, right? That the ideal versus the implementation, and this comes back to what Risa was saying.
Thank you, everyone, for those great sum-up comments. I think really important, I guess, and it is always about how these translating the words on a page into action, I think is absolutely vital. I think, Brenda, did you want to say something first before we go to the Q&A?
Yeah, thank you, Harry. I just wanted to first thank our panelists. That was really interesting. And I have a comment question, and I'm hoping perhaps all panelists might have some thoughts. But, a few years ago, I did my master's thesis on the impacts of NAFTA on Indigenous peoples with James. And, there weren't a lot of people thinking about it, but, James is right. At the time, the initial concerns was, how is NAFTA going to impact Indigenous peoples? And as the new NAFTA came out, more interest in thinking a bit more proactively about it. But what really came through, for me at least, in the talks, as my work now so much focuses on implementing the UN Declaration and the rights, is international trade actually a really important way to implement the rights of Indigenous peoples that are recognized in international human rights law? And I think you've all sort of touched on it, but it just sort of really crystallized for me today. And so I saw Risa nod, so I think she agrees with that. And I think people are saying that, and I'm wondering, I mean, do you agree with that statement? And if so, like, where and how do we start? And I think you've all sort of started with those ideas. And I think that's sort of what people were talking about. But like, if you had to pick a sort of right? Like, here's a really good place, like, or this is where we start. Do you have sort of more to contribute? And I think that's where the conversation was kind of going in the responses, but I'm wondering if people could be, I don't know if it's more practical or more tactile, like something sort of, what could we latch onto? So people who are just thinking about trade, what's our hook? Where's our starting point?
Would you like me to kick it off, Brenda? Okay. When the first conversations were being held about the Trade Indigenous Peoples chapter, one of the goals was to incorporate a commitment of all three states, again, to implement the UN Declaration on the Rights of Indigenous Peoples. So that is definitely something that's been thought about by at least the Canadian government that made the proposal. And that's because the UN Declaration on the Rights of Indigenous Peoples, as of course is it, of course, is a human rights instrument, but it's also a social and economic instrument. and it's so intertwined with the right of land rights that it is the implementation and mentioning it in trade agreements and making sure that it's aligning with the principles of the UN Declaration, I think, is very important. And as James also mentioned, self-determination and Articles 18 and 19 of the UN Declaration, which both speak to the participation of Indigenous peoples through their representative organizations and participation in international and other agreements. So I think that it is very intertwined. It's an influence, I think, as well as something that needs to be better woven through trade agreements. I think there's so many conversations about how international law is fragmented, and this is an area where we're trying to bring trade and Indigenous people's rights together to make sure that it's not as fragmented in this one instance as it has been. Thanks.
James or Sergio, did you have any more thoughts on this question? And a part of this trigged, even when James was talking about broadcasting, right? Because there's rights to Indigenous-owned media under the UN Declaration. But how do you go about implementing that? And I don't know the provisions as well in that area in international trade, but I think it's really inspiring and intriguing. I don't know if either of you have thoughts, or if we'll move to the question from our participant.
I do, but I want to hear James first.
Well, just, I don't know if I can add anything new. I wanted to mention, this ties into what Sergio was saying, I think, which is to say, look, it's international trade. It's not a panoply of remedies. It's within the confines, for example, of international trade that we're going to try to articulate the rights of Indigenous peoples and try to create some remedial type of justice, if you will, or fairness or equity. It's not going to fix everything. And you really have to be mindful of that at the ground level, particularly with Indigenous communities that have a history of being taken advantage of by the government, and also have a history thereby of their own internal sense of failure. And this I've seen, for example, in northern Saskatchewan, like in Sonora, Mexico, where you have this outbound economy where literally a dollar goes in and $3 comes out. And I think this is these community dynamics one has to be very, very mindful of within the Indigenous perspective. But having said that, I think it's worth trying something. And I think that it's this, particularly under the circumstances that we're experiencing right now with the pandemic, it's a really good time to reassess the role of government and the idea of the public good and the public trust, and to call upon government to innovate and to experiment and to work in partnership with different actors. Because I know all too well, for example, with trade, there's this kind of pre-existing structure in place vis-a-vis power and the way money flows. And it's also interesting too, because when I go to the table with governments, I'm talking very low dollar amounts. We're talking about shirts and really simple things. We're not talking about a lot of money, which is also hard to get people interested in terms of financing. But so there needs to be a space created where I think little incubators can be developed, and they can either succeed or fail, and that knowledge can be shared and made transparent, and it needs to be current information as well. That's terribly lacking in the field of Indigenous studies generally, is current information. A lot of the socioeconomic case studies go back to the 80s, and a lot of things have changed since. Those are just some reflections.
Yeah, thank you, James, and I agree with that. And I mean, I see this in very pragmatic terms, right? I mean, I want to be optimistic, and I think like part of what I do with the book is try to leave it in a more hopeful note. But I do think that there's still like a lot to do, and just resisting parts of the creation of vulnerabilities. And I think if you ask me where to start, I think the aspects of international economic agreements that create more vulnerabilities and addressing those, right? And I think those for sure are bilateral investment treaties, right? The investment aspects of international treaties still create or exacerbate vulnerabilities of indigenous peoples. And I think this is what I mean, if I were to be an advocate, right? And I think rightly so, the past special rapporteur of indigenous peoples put the eye on that, right, on the question of bilateral investment treaties and that what can they do. And I think if we have to be more careful of how they are designed. They are designed not to enable or exacerbate, the land takings and the land, the commoditization of land, and in part because those, I think, investment treaties have been very instrumental for petroleum and oil companies that are actually, very implicated on the, the consequences of or some of the bad consequences that these treaties have, right? So I think there is one aspect that I think I would like to highlight, and that's mostly, continue a little bit the resistance on some aspects, right, and try to, maybe, ISDS will never disappear, right, now that, although between the US and Canada now is phasing out, but, will remain there, but like finding ways of enhancing the possibility of having counterclaims or claims by individuals, claims by business actors, relying on those type of treaties to create causes of action to sue corporations that damage indigenous lands or affect indigenous peoples in different ways, right? So I think that's an area that remains there on the protection side. And then you're right. I mean, like, let's just be also hopeful, right? What in which ways we can create economic opportunities. And one way is, from top down, right? Like, try to use leverage and power, right? Raw leverage and power. The U.S. government has more power over Mexico than many other that most governments, if not all governments. And then they could actually, try to generate a more kind of like a powerful transformation in Mexico, as they did with the labor reform in Mexico with the USMCA. And yeah, I think like James also points into the realities of this, right? Like at the end, we have to be careful not to ask too much of international trade, because that's sometimes what happens, right? We think like international trade is going to correct that, and the vulnerability of indigenous peoples, at least in Mexico, now that I have had a little bit more of context by working in the Constitutional Reform Commission, is vast. And I had this wonderful chat with this woman who is amazing, who lives in a city in Florida, and she was relating to me, and she went to one of the meetings for the commission. She's just, she wanted just to be at the meeting because of the symbolism of that, and she was risking not being able to come back because she's obviously undocumented in the US. She's an indigenous seal, and indigenous people go to the US, work in the hospitality business, and then they obviously have kids, and sometimes they leave their kids as they do in their villages in Mexico, being taken care by other kids, and then suddenly they face the authorities taking their kids from them, right? And then they conduct hearings. And the judges don't even know that the people don't speak Spanish, right? Like, because they speak Tzotzil, and it's just, I mean, with the political economy that we continue to have in North America in many ways, right? We have to be careful not to think that trade is going to be the solution and address very fundamental aspects of human rights that remain, especially, I mean, with the past administration and the immigration policies, but I'm hopeful and I'm optimistic as well. So I hope not to take away from the positive side, right? I think there are opportunities, and I think building on examples of success, right? To create market access for indigenous people. One other way, right, and I think this has been debated, right, is kind of create a kind of a confederation of nations that actually, within at least in the North American, create this idea of a free trade agreement within indigenous peoples and indigenous lands. And so I think that has proven to be a very difficult concept to implement, but keep exploring and innovating in that area.
Thanks, Sergio, and thanks, James and Risa as well, and Brenda for your question. We've got one Q&A question that's been posted. I've just been told we need to just sort of conclude quickly, but we'll finish with this Q&A that's been posted. Can everyone see that online, or should I read out the question?
Maybe just read it out, Harry.
Yeah, I'll read it out. Yeah. So this is from Guillermo. How would Article 32.5 of the new NAFTA play in cases where an inappropriate consultation with Indigenous communities was done by the government prior to the signing of licenses or concessions for oil and gas exploration with foreign companies? So you've got an inappropriate consultation by the government that's done, or an inadequate consultation. So Guillermo asks, the fact that the consultation was done through government actors matters, or doesn't matter for the purpose of Article 32.5, because this is the case of licenses for extraction in Mexico. The companies act on behalf of the government in the oil and gas activities. So the question, I guess, is, does it matter that the government has done an inadequate consultation, and what happens then? I'm not sure if anyone would like to start.
I can try. It's a very complex question in that consultation and lack of consultation, usually the remedy is more consultation. So that's what we see, that it doesn't always lead to actually canceling a permit. But, and also in this case, you have to remember that Article 32.5 protects Indigenous rights through the action of states. So really it's protecting states to take the measures to protect Indigenous rights. So if a country does inadequate consultation, and I think that in itself wouldn't lead to a dispute, to Section 35 being used. It's only if the permit itself was canceled, but by that state, that would be where the dispute was handled. And it could be that it would be due to the consultation, the results of the consultation, it would lead a country to cancel a permit. So certainly the consultation would be part of the defense, and that's why it's important for Indigenous peoples, the ones who were consulted, to be involved in the defense of the dispute. But I think when you look at Article 32.5, it is to protect the measures taken by the member states. And so I think consultation would have to lead to the cancellation of the permit by a state actor for Article 32.5 to be relevant.
Thanks, Risa. Sergio, I've seen you've unmuted yourself.
Yeah, I was just going to say, I think I agree with Risa's take. I think, I will have to understand more the example, and I think Guillermo has also written a very interesting scholarship on the topic of the intersection of oil and gas and investment and Indigenous rights. So I will ask him the question, right? But I agree. I think part of this is to think the consultation as a protective mechanism of human rights, and a lack or a defective consultation doesn't necessarily violate the rights, right? I mean, it can lead to the violation of rights, and if it leads to the violation of rights, then maybe states can cancel, right, that contract, and if it cancels the contract, then you have an international issue under the NAFTA. But countries can decide, the lack of consultation can in itself not be violatory per se of rights, right? Although, that will have to be proven. And the other thing is the lack of consultation. If violates rights, it may or not result in the cancellation of the contract, right? I mean, it can lead to other type of remedy, right? That is not the cancellation. But yeah, I mean, these type of issues I think are emerging and becoming much more salient, I think, with the institutionalization of consultations, especially now throughout Latin America. And I think, you know, obviously the US and Canada now have very formalized mechanisms. But I think, in fact, you have there. No, I mean, I think there is a precedent for a similar type of case, an investor-state dispute settlement. I think the Glamis case, I think, had some of these elements as well, if I remember correctly. But yeah, I don't know. Maybe James knows a little bit more.
Yeah, just briefly, and I'd like to follow up on Guillermo's scholarship on this. So the Supreme Court of Canada in February made a landmark decision that has received very little attention. Again, I think it's because of the pandemic, but this is in regard to mining companies abroad. And so in the case, if it's a Canadian company, what I'm getting at is look at the domestic status of the corporation to see if there's any type of hook that you can get into the company for compliance. And the Supreme Court of Canada in February really delivered a very strong message to Canadian mining companies that they've done some terrible things. And so this was a case where, you know, the mining company, I think they were just egregious. And the Supreme Court just said, you are basically liable for the human rights standards of this country. You can't go abroad doing this. And there's all sorts of clever arguments you can develop if it's a Canadian company getting any type of financial assistance. We've already talked about the World Bank. There's similar types of protocols now with Canadian banks. I don't want to sound like this sounds like an exciting case to take on, but there are possibilities that were not there 20 years ago. So, and so the bottom line is, I think that the new NAFTA creates a framework. But it's not everything. It's not the be all and end all. There's still what you might call higher law, if you will, in the international instruments that the nation state has signed.
Thank you. Well, I think we're probably just about out of time. I really wanted to thank all of our panelists for all of their expertise today and sharing all their wonderful thoughts, and to all of you for attending. Today, I think we really managed to highlight both a career opportunity if there's any graduate students out there or others looking for new areas of work. There is a wealth of international human rights experts that focus on Indigenous rights, and there's a wealth of international trade lawyers. But I think what we've seen today in the conversations and both Sergio's work and the book that Risa edited really highlighted that there's very few experts that have brought together these areas. So it's an area that's ripe for a lot of consideration. And highlighting the challenges with that last question, that at this point, what we have in international trade law is more of a shield trying to protect Indigenous people's rights from negative impacts of trade, but hopefully some opportunities that we can see to start actually using international trade law to advance Indigenous people's rights. And so I hope that this was informative for everyone. Perhaps we can do some virtual clapping and thank our panelists for taking their time with us today. And I don't know, Harry, did you want to say any closing remarks?
Just to echo that, Brenda, thanks everyone for attending. Thank you particularly to panelists who gave really interesting and insightful presentations. Difficult, obviously, in such a short time, but you've all managed to do really well and really engaging. So thank you again. I just want to say that this has been recorded. It will be available on the ASIL YouTube website, and we'll also send a link to everyone on in the interest group via email when it is ready. and it's been a great success. So we'll obviously always encourage more webinars. So if you have any thoughts on another topic in the future, please let us know, and we can try and organise that with your support. So thank you again.